I'm Judge Knowles. Welcome to our Employment Tribunal. This is a complaint of unfair dismissal by Mr. Darrell Cookson against his former employers, Buffet King Limited. Mr. Nagel, I understand you're representing the claimant?
That's right, ma'am.
There's just the claimant's witness statement. No other witnesses?
No other witnesses, ma'am.
Mrs. Molenscott, you're representing the respondent, I believe.
That's correct, ma'am.
And I have statements for a Miss Abby Paulson, dismissing officer, and Mr. Neil Chadwick, appeal officer. Is that correct?
Yes, ma'am.
I'm not aware that there are any preliminary issues to be dealt with in this case, are there? Can you just confirm?
None from me, ma'am.
None from the respondent, ma'am.
That's good. Well, given the burden of proof in unfair dismissal claims rests with the respondent, I think we'll move straight to the respondent's first witness, Miss Abby Paulson.
Good morning, ma'am.
Good morning, Miss Paulson. I understand from the clerk that you wish to take your oath by affirming. Is that correct?
Aye, that's correct, ma'am.
Thank you. So you should have received a document from the tribunal which has in it the wording of the affirmation. Do you have that in front of you, Miss Paulson?
Yeah, I do.
Okay. Will you just read the affirmation out loud?
I solemnly affirm that the evidence that I shall give will be the truth, the whole truth, and nothing but the truth.
Thank you. Now, your representative, Ms. Paulson, has previously submitted your witness statement to the Employment Tribunal. Do you have a copy in front of you there?
Yeah, I do.
Mrs. Molenscott and Mr. Nagel, I know it's normal procedure nowadays to take statements as read, but on this occasion, I'd like the witnesses to read their statements out. So, Ms. Paulson, if you could read your witness statement out loud, please, and take your time and go ahead when you're ready, please.
My name is Abby Paulson of Buffet King Limited, 88 Tasty Avenue, Liverpool, L17ET, which address I'm employed, and I will say as follows. I'm the head of sales at Buffet King Limited, and I've been with the company since June 2016. The claimant was employed as a regional sales associate in Greater London and was one of my direct reports. Buffet King Limited provides catering services to offices and for events. As such, when the coronavirus pandemic hit, the impact on the business was significant. Our business relies on people being in the office, holding face-to-face meetings and events, and all of these things just stopped overnight. When the furlough scheme was announced, almost all staff, including myself, were furloughed, as we simply did not have orders to fulfill or opportunities to work. For months, the company survived on a skeleton staff to keep it ticking over. Even when lockdowns eased temporarily, because most events couldn't go ahead and many people continued to work remotely, there wasn't enough work to bring the employees back. It was not until March of 2021 that I returned to work. We started to plan for the gradual easing of restrictions. What was clear from very early on is that the catering we supplied to offices was never likely to return to pre-COVID levels. We'd seen several of our office-based clients cease to exist during the pandemic, a number of whom were based in London. Not only that, of our surviving clients who utilised us for office catering, a significant number had embraced home working, hybrid working, and were holding significantly less in-person meetings. When looking at new business opportunities moving forward, we also had to take into account that the move to hybrid working and the greater use of platforms such as Zoom and Teams for meetings meant that in terms of office-based catering side of the business, projections showed a continued reduction in profit. The return to events were also projected to be slow, but we were hopeful that as time passed, these would reach pre-COVID levels or at least close to. That said, even when taking an optimistic view, we couldn't rule out the potential impact of further waves, lockdowns or tiers being applied, which could impact on such events. Given the loss of business and the opportunity, we were forced to look at reducing our overheads. We negotiated terms and changed suppliers and reduced our own office space, But given the downturn in work, we also had to look at ways of reducing headcount. Whilst it's accepted it as a sales team was still required to drive sales and create new opportunities for the business, it was clear that we no longer required the size of team we had prior to COVID. As such, we looked to reduce the team in 3 areas: admin, telesales and regional sales. In respect of admin, we removed the role altogether, and in terms of the telesales team, we reduced the headcount from 3 to 2. When it came to the regional sales, we had to consider the impact on London specifically. London had been our hardest hit of all regions due to many offices not returning at least to full capacity, which had previously made up most of the sales and opportunities in that region. It is also the region with the highest overheads, in particular in respect of logistics and delivery. As such, the decision was made to pull out of London, save for the very occasional large events. We announced the redundancies were going to take place in a meeting with the full sales team on the 2nd of April 21. I explained to the team the devastating impact of the pandemic had had on the business and the resulting proposals for redundancies. Minutes of the meeting were taken. I can confirm they are accurate. Following on from the meeting, we notified all affected employees that they were at risk. In respect of Daryl, that was confirmed by a letter dated 3rd of April 21, and he was invited to attend a consultation meeting the following week. He was invited to put forward any proposals he might have, and I made it clear, as I did with all employees at risk, that I could be contacted with any queries. I met with Daryl on the 9th of April 21. He had been offered the right to be accompanied but chose not to exercise that. At the meeting, we discussed the reasoning behind the redundancy situation, which he seemed to accept. He did, however, query why he was not placed in a pool. I had considered this. We used a pool in respect of the telesales position, but they all work at head office and the roles are largely identical. It didn't, however, seem appropriate in the circumstances to apply a pool in respect of the regional sales. Whilst all regions had been equally hit by lockdown, initially it was Daryl's region that was ultimately the worst hit because not only the loss of existing clients, but also the loss of opportunity. The Greater London region focused very heavily on catering for offices and meetings, whereas everywhere else the focus was on events. The consultation was summarised in my letter to Daryl dated the 10th of April 21. In that letter, I also invited to attend a further consultation meeting on the 16th of April. He was reminded of his right to be accompanied and advised this time that if he were unable to identify an alternative, one possible outcome of the meeting would be his dismissal by reason of redundancy. I met with Daryl as planned on the 16th of April 21. He attended unaccompanied, but was happy to proceed. I did check during the meeting whether there would be any possibility of him relocating, as this could have opened up the possibility of bumping, but he confirmed this is out of the question. His only proposal to avoid redundancy was to allow more time for things to potentially improve. However, that wasn't a viable option for the business, and it was one we'd already considered. He did query again his selection, but I explained that it was his area that had the greatest decline, and I reiterated our intention to move focus away from the region almost entirely. This was not the case for any other region, as neither Daryl nor the company were able to identify any viable means of redundancy. It was therefore confirmed to him at the consultation that he was being made redundant. I confirmed my decision and reasoning by letter dated 16th of April 21. The letter also set out Daryl's right of appeal, which he duly exercised. This concluded my involvement in the process. In the end, across the company, we reduced headcount by 15 people, 3 of whom were from the sales team. It was not a decision that was taken lightly, and I would of course have preferred my full team to have stayed, but it simply wasn't feasible for the ultimate survival of bookmaking. I hereby confirm that the facts stated in this witness statement are true.
Thank you, Ms Paulson. Mrs Mollenschott has indicated she doesn't have any supplementary questions for Ms Paulson. So, Mr Nagel, do you have any questions for Ms Paulson by way of cross-examination?
I do indeed, ma'am.
Okay, go ahead, Mr Nagel.
Thank you. Morning, Miss Paulson.
Good morning.
Can I just ask you to read out the first sentence of point 9 of your statement again?
Yeah, we announced that redundancies were going to take place in a meeting with a full sales team on the 2nd of April 2021.
Very definitive there, weren't you?
Yeah.
And that's because your mind was already made up that Mr Cookson's employment was to be terminated, wasn't it?
No, just that the financial performance of the business and the forecast for the coming year meant that we had to consider redundancies.
But you didn't say that redundancies may need to take place or a potential redundancy situation had arisen, did you?
Maybe not in so many words, but when I made the announcement, I definitely talked about people being placed at risk. And I did stress no final decision had been made.
And that will be the announcement at pages 36 to 37 of the bundle, will it?
Yeah, that's right.
Looking at this, you're right when you say it refers to some members of the sales team being placed at risk and no final decision having been made. But that's at odds with what you say in your statement, i.e. that redundancies were going to take place, isn't it?
I suppose you could read like that, but I definitely did say those things in the announcement.
Am I right in thinking that the announcement was prepared by HR?
Yeah, Megan Carter in HR helped me put it together.
But your statement is your version of events in your own words, isn't it?
Well, yeah.
So when you say in your statement that redundancies were going to take place, there are no if, buts or maybes there. And that's because your position from the outset was that redundancy would definitely occur. That's right, isn't it, Mrs. Paulson?
Look, you're trying to put words in my mouth here. Maybe I've not worded that right. Redundancy consultations were going to take place. It was always clear to me, and I made sure it was clear to everyone else that no final decision had been made.
So what did you understand the purpose of the consultation period to actually be?
Well, to talk through everything with the employees affected by the situation.
New to redundancy processes, aren't you, Miss Paulson?
Well, actually, I'd done a couple in the past in a previous employment, and I was doing the admin and the telesales redundancies around the same time.
How many redundancy processes have you managed prior to taking charge of the one that resulted in Mr. Cookson's dismissal?
Well, just 2 a while back, and then I had the sales team ones running.
Okay, we'll move on. You didn't have any concerns with Mr. Cookson's conduct or performance, did you, Miss Paulson?
No, not at all. He'd been fine on both counts since joining us back in 2017.
And could the same be said for the sales reps in the other regions?
Yeah, they're a good bunch.
And are the skills and experience required of your sales reps the same across all regions?
Well, broadly speaking, they've got the same duties and responsibilities.
And with reference to the RSA job description on page 34 of the bundle, this is common to all regions, isn't it?
Yeah, I think so.
So based on the answers that you've given to my last 4 questions, is it fair to say that all of the company's RSAs were the same in the company's eyes as far as the requirements of their roles, their conduct and their performance were concerned?
Well, in terms of the skills required and the basics of the role, yes. And no, there was no problems with any of their conduct or performance, but this was redundancy. It wasn't performance or conduct.
Well, that may be so, Miss Paulson. But when we look at the financials on page 35 of the bundle, the company was prepared to lose the sales rep responsible for its second most profitable region pre-COVID. Doesn't that strike you as strange?
Well, no, because it was the changes that COVID brought about that led to London forecast being so bleak.
With reference to point 11 of your statement, you say you did consider placing Mr. Cookson in a pool. What form did that consideration take?
Well, I sat down and thought whether I should do it like I was doing the telesales redundancies. I definitely had a long, hard think about that. And I had a chat with Meg in HR, but we were talking entirely different regions this time, so I decided not to.
Please refer me to any document in the bundle that evidences that you considered placing Mr. Cookson in a pool.
Well, there isn't one in the bundle because, like I said, I just sat down and had a think about it and chatted to Meg.
That conversation never took place, did it, Miss Paulson?
It absolutely did. I spent some time thinking about it in the office. I'd come to the conclusion that it was right to have a pool of one, but I wanted to sense check my thoughts. So I was on the way home. I called Meg from the car. I remember she was on the way home too. And I just went over my thoughts about it being regional, the types of clients being serviced, the plans going forward, and just basically said, look, am I off base here? And Meg said no, she thought it was the right approach in the circumstances. So that left me quite confident in my decision.
But how convenient that there isn't any such documents back any of that sort. I put it to you that the reason for there being no such document is because no real consideration was actually given to placing the other RSAs in a pool with Mr. Cookson. The redundancy consultation process was a sham, and there was a hidden agenda to get rid of Mr. Cookson. That was the reality of the situation, wasn't it, Ms. Paulson?
100% not. We didn't want to lose Daryl, but the business case for redundancy was clear.
With reference to point 13 of your statement, you say that during the second consultation meeting, you checked with Mr. Cookson whether there would be any possibility of him relocating, as this could have opened up the possibility of bumping. If Mr. Cookson had stated that he was prepared to relocate, it would have been one of the other RSAs you'd have considered bumping, right?
I'm not sure what role it would have been because he immediately ruled out relocations, so we never got that far.
Well, I suggest to you, Ms. Paulson, that had the company been serious about considering bumping another employee in order to retain Mr. Cookson, it would have been one of the other RSAs you'd have considered bumping. And that if you were prepared to consider that, it stands to reason that you would have pulled the RSAs, because to not do so risked you losing Mr. Cookson as one of the top performers in the role. That this didn't happen is evidence that there was an agenda to get Mr. Cookson out. Isn't that right, Ms. Paulson?
Definitely not. We'd have kept Daryl if things had been different in London, or if he'd been prepared to move, we could have looked for more options, but it wasn't the case.
But if he had been prepared to move, you'd have considered bumping. And if it was one of the other RSAs you'd have bumped, logic dictates that they should have all been pulled so they could have been selected for redundancy based on a scoring process. That's right, isn't it, Ms. Paulson?
But that's not what I said. If, for example, he'd been prepared to move, then I could have looked at head office roles for bumping, but he was clear that was not an option.
No further questions, Mark.
Thank you, Mr. Nagel. Ms. Paulson, I have just one further question for you myself. Mr. Nagel asked you about the consideration you gave to what the appropriate redundancy selection pool was. Can you just be clear for me on the factors which actually led you to decide that only the claimant should be in the pool?
Yeah, so basically, well, first thought about was the region, because obviously we work in very distinct regions. They don't move in and out of the regions, they don't swap. So first of all, that was sort of number one consideration. Then I also looked at the fact that actually when you looked at the regions individually, there was a difference in the type of clients they were dealing with, not just in terms of the actual client themselves, the company, but the type of work they were doing. So Daryl did an awful lot of his work that related to catering into offices in London, but also into in the face-to-face meetings, where he did very little in respective events. When you looked at the other sales representatives, they were the complete polar opposite. They did very little in terms of office, and their clients were completely different. They were in the events industry. So even though they were all sorts of sales people, the actual working that they were carrying out wasn't just different in terms of the region it was in, but it was quite different in terms of the work they were going for, and the skills to get that work, the contacts to get that work are completely different.
Thank you, Ms Paulson. That concludes your evidence. Thank you. Mrs Molidge-Scott, any re-examination?
No, ma'am.
Thank you.
That's the first part of the hearing concluded, and the cross-examination of the respondent has been done. At this point, evidence from the appeals officer, Neil Chadwick, would normally follow the same format. But in the interest of time, bearing in mind it's already a full morning's event that you've invested in attending today, this will be omitted from the mock tribunal. We could, I suppose, ad lib in saying that, having seen Mr. Nagel's cross-examination of the respondent, then if Mr. Chadwick was subject to the same kind of cross-examination, then maybe he needed to take a break, something like that. But we've kind of just kept it out of the event to save a bit of time.
Mr Cookson, it's now your turn to give evidence. Good morning, Mr Cookson.
Morning, Mal.
As with Ms, ask you to read the affirmation wording in the document that you should have in front of you.
You can indeed. I solemnly affirm that the evidence that I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you. And do you have there a copy of your witness statement, which you signed on the 3rd of September 2021?
I do, Your Honour.
Okay, then please read through the statement out loud, Mr Cookson, just taking your time as you go.
Okay. My name is Darrell Cookson, and I will say as follows. I commenced employment with Buffet King, the company, as a regional sales associate rep for the Greater London region on the 6th of September 2017 until my dismissal on the grounds of alleged redundancy on the 16th of April 2021. On or around the 20th of April 2020, me and the reps for the other regions were placed on furlough. I remained on furlough for the remainder of my employment with the respondent. On the 2nd of April 2021, I was invited to a group announcement which was made to the whole sales team. Me and my colleagues were informed that the respondent was looking to cut a number of roles from the sales team, and those who were at risk would be notified separately and a consultation process would be commenced. I was taken by surprise by this, as COVID restrictions were being lifted. Everything was about to open up again. People were set to return to offices and events were once again being planned. Given my role was focused on generating business in this regard, I didn't expect to be placed at risk, as it was obvious that the respondent would need a sales team out in the field. But by letter dated the 3rd of April 2021, I was informed that my role was at risk, and I was invited to attend a consultation meeting. I contacted a fellow rep, Bob Foley, to express my disappointment at this, only to find out that Bob hadn't even received an at-risk letter and wasn't required to attend a consultation meeting. The consultation meeting took place on the 9th of April 2021, and I met with a head of sales, Abby Paulson. I told Abby I didn't really think there was a need for redundancies, because the office is opening up again and events now being planned, there seemed to be a need for the work that I normally did. During the meeting, it also became clear to me that out of all the reps, I was the only one who'd been placed at risk. As I've always said, if someone had to be made redundant, I definitely think that the other reps should have been in the same position as me, and that the company should have scored us against each other to decide who. After the meeting, Abby wrote to me with a summary of the meeting and invited me to attend another consultation the following week. That took place on the 16th of April, and I asked for the opportunity to prove my worth before a decision on redundancy was made. But that seems to fall on deaf ears. I also reminded Abby of my opinion that the other reps should be considered for redundancy alongside me, but that didn't seem to go anywhere either. At the end of the meeting, Abby told me I was being made redundant and that I'd be paid my notice and wouldn't have to work it. That was confirmed to me in writing on the same date. I obviously appealed and had a meeting about that with the MD, Neil Chadwick, on the 27th of April. Just as I did with Abby, I told Neil that my redundancy wasn't fair, and he said he'd go away and investigate. Can't have been much of an investigation, because he wrote to me later the same day rejecting my appeal and confirming that I was still redundant. Now more than ever, I'm convinced that the company were too hasty in making redundancies. Worse than that, I'm sure there was an agenda to get me out. I mean, the fact they didn't consider the other reps for redundancy surely proves that. After all, my role was no different to theirs. Therefore, I'm in no doubt that I've been unfairly dismissed. I confirm that this statement's a true account and my recollection and understanding of events.
Thank you, Mr. Cookson. Mr. Nagel has indicated that he doesn't have any supplementary questions for you. So, Mrs. Molenschott, do you wish to cross-examine Mr. Cookson?
In your capacity as Regional Sales Associate for Greater London, it was your job to visit clients, secure new business, maintain relationships with existing clients, and to facilitate continued use of the catering services. Is that correct?
Yeah, that's right.
And you consider yourself good at your job. You fostered good relationships with your client, did you not?
I did. I had a lot of repeat customers.
Of those repeat customers, how many were for events?
None, but there's so much competition for events catering in London.
So all of your returning customers were those for office and meeting catering?
Yes.
In fact, they make up the vast majority of your clientele, new and repeat, is that right?
Well, yeah.
You mentioned you were placed on furlough in April 2020, along with the other representatives from other regions.
Yeah, we all were.
In fact, others in the company were too, leaving just a skeleton staff.
Well, I don't know exactly, but yes, that seems about right.
Are you aware of anyone in the sales team who wasn't?
No, I'm not.
And surely you appreciate that with lockdown stopping all events and people being instructed to work from home, that there's no work coming in for a business like the Respondents.
Well, obviously, there wasn't anything joking about that.
You agreed earlier that you fostered good relationships with your clients, so presumably you are aware that some of your clients were so badly impacted by the pandemic they ceased trading.
Some have, yeah. But others reopened.
You said everything was about to open up again. That's not everything then, is it?
Well, obviously not companies that have gone bust. That's not what I meant.
In your statement, you said people are set to return to offices. Are you suggesting that everyone will go back despite the success many firms have had utilising home working?
No, I'm not suggesting that, but offices will open.
So, you accept not all offices will reopen. You accept not everyone will return. But you seem to think this won't mean a continued downturn in business.
All right, maybe in the short term, but eventually those clients who went bust will be replaced. And those who have less people in can be balanced out by new clients.
So at best, it's going to take quite some time to get back to pre-COVID levels.
Well, yeah, I mean, these things don't happen overnight, do they?
And of course, there's no guarantee, like you said. There's plenty of competition in London and now fighting for a share of a smaller pie.
Nothing's guaranteed, but we could have tried. I lost my job because he didn't even give me a chance.
When you raised that suggestion to Abby, it was explained to you that this had been given consideration, was it not?
She said it had, but I don't know.
Well, do you have any evidence to suggest she lied?
No.
Well, so it didn't fall on deaf ears, did it? She heard you, she responded, she explained. She just didn't agree it was viable.
Well, I think it should have been tried before putting me out of work.
But it's just a difference of opinion then.
Well, I guess you could call it that, yeah.
Then moving on now to selection. It's your belief that you should have been placed in a pool.
Yeah, with the other sales reps.
If they'd been included, would it have been fair then?
Yeah, then it would have been.
Interesting. So it would be fair without giving another rep a chance, but not when it's just you.
That's not what I meant. But yeah, my main issue's always been that he should have schooled me against the other reps and the worst one should have gone.
How familiar were you with their clients?
Well, not very, but I could have got to know them.
So relationships would start from scratch.
Yeah, but I've done that before.
Do you know enough about their clients to know how much of their business is office and meetings and how much is events?
Well, not exactly, but I've got an idea.
So presumably you do know that they're in an opposite situation to you. Their clients are predominantly events-based.
They still did office work, just like I still did get work for events.
Well, that didn't answer the question, did it? Do you accept that their clients were predominantly events-based?
Yes, they were.
So not identical roles.
Nearly enough. We all did both, just opposite ways, right?
And not the same clients?
Well, obviously not.
And not the same area?
Well, they're hardly going to send someone in Scotland to London and vice versa, are they?
And you were aware of the intention to redirect focus away from London?
Well, yeah, that's what he said.
Because the overheads are higher there, aren't they, in terms of delivery and logistics?
Yeah, probably.
So you can see the sense in the move.
From a cold-hearted business perspective, yeah. But I wouldn't put someone out of a job they're good at without giving them a chance.
You appealed the decision to Neil Chadwick, didn't you?
I did.
And that appeal was limited to 2 points: the pool and the fact you felt it was a stitch-up.
Yeah, that's right.
You are aware that you were not the only person made redundant in the process, aren't you?
Yeah, I know there were a few.
There were 3 in your department alone.
Yeah, I know. I know there was 3, including me, and I know there was others in the wider business.
So obviously you're aware that the redundancy situation, it doesn't just impact you. In fact, the stitch-up allegation was based solely on the fact you felt the decision not to pool was unfair. So you've assumed some form of ulterior motive.
Yeah. Well, I can see no other reason at all not to pool.
So no other evidence other than the lack of the pool of this stitch-up.
No.
Now, you criticise at the speed at which you received the appeal decision.
Yeah, he wrote it to me the same day. So what investigation could he have done?
Well, you only really had 1 point of appeal, did you not? I mean, it all centred on the pool.
Well, yeah.
So other than confirm the reason behind the pool of 1 and consideration of that, there wasn't really anything else, was there?
Come on. We're talking about the MD here, that he can do an investigation within 24 hours. Something stinks to me. Very, very quick.
Thank you, ma'am. No further questions.
you, Mrs. Molen-Scott. Mr. Cookson, just a question from myself. You said in cross-examination that you felt that you were stitched up because the respondent didn't include the other RSAs in the selection pool. And if they had, you consider that the process would have been fair. Are you therefore accepting now that you think that, regardless of you thinking that the pool should have been wider, that the reason for your dismissal was redundancy?
Look, I get it, Your Honour. The business was going through hard times, and that's why I've been on furlough for so long. I think I said as much at the first consultation meeting. I've seen the financials and I'm prepared to believe it ain't, creative accounting. So yeah, I do accept that there was a need for redundancies. My beef has always been, why me?
Thank you, Mr. Cookson. Mr. Nagel, do you have any re-examination?
No re-examination from me, ma'am.
Thank you, Mr. Nagel. As that concludes the evidence, I suggest we adjourn for 20 minutes before closing submissions. Mr. Nagel, Mrs. Molen-Scott, please restrict your submissions to no more than 10 minutes. Thank you.
So we're going to turn our attention now to the closing submissions, and first up will be the respondents' closing submission.
So Mrs. Molen-Scott, can you give me your closing submissions, please?
Of course, ma'am. The claimant brings a single claim of unfair dismissal against the respondent, Buffet King Limited. It is the respondent's position that the dismissal was for a potentially fair reason, namely redundancy, and that in carrying out the dismissal, the respondent adopted a fair process and that the decisions during that process fell within the range of reasonable responses. It is now seemingly accepted that a genuine redundancy situation existed and that the test for a redundancy dismissal, as set out in section 1391 of the Employment Rights Act 1996, has been met. For the sake of clarity, it is the respondent's position that the requirements of the business for employees to carry out work of the kind performed by the claimant in the place where he was employed had diminished. The pandemic had a devastating impact on the respondent, as it did on many. And as things began to reopen, forecasts made it clear that recovery in the Greater London area was highly unlikely, given the increase in home and hybrid working and greater use of remote video conferencing facilities such as Zoom and Teams for business meetings. This led to the respondent's decision to pull out of Greater London area, in particular, given the higher delivery and logistic overheads. The claimant makes no criticism of the process, save for one element, the decision to place him in a pool of one, as opposed to including all regional sales associates. In light of this, the tribunal will need to consider the following. Did the respondent genuinely apply their mind to the issue of who should be in the pool? And if so, did the dismissal lay within the range of conduct which a reasonable employer could have adopted? As set out by Justice Mummery in Tamac and Ryan, the question of how the pool should be defined is primarily a matter for the employer to determine. It would be difficult for the employee to challenge it where the employer has genuinely applied his mind to the problem. It is respectfully submitted that those within the respondent tasked with defining the pool did just that. They applied their mind. The evidence given by Abby Paulson, who defined the pool, and by Neil Chadwick, who investigated the rationale behind that definition, are testament to that. Ms. Paulson considered not only the fact that it was specifically his geographical area in which the claimant worked that had diminished and was to cease almost in its entirety, but she also considered the differences in the work carried out, which, whilst on paper appeared similar, involved a different focus, events versus offices, and flowing from that, by the claimant's own admission, different clients. The next question to consider as set out in the case of Williams and Compare Maxim Limited, is whether the dismissal lay within the range of conduct which a reasonable employer could have adopted. The respondent limited the pool to one employee carrying out the particular kind of work in the place where it had severely diminished. The prospects of recovery in the area in which the claimant was employed were indeed so poor that the respondent had resolved not to actively pursue sales in that area. In addition to this, the claimant worked predominantly, almost exclusively, on office and meeting-based catering, with events catering making up just a very small proportion of his work, and none of that was repeat business. Now, this differed significantly to the work carried out by the other regional sales representatives. Finally, I would stress that the question is whether it falls within the range of conduct that is reasonable. It is not necessary that it be the only reasonable course of action, and views should not be substituted, only reviewed in the context of that test. As such, it is respectfully submitted that the respondent has met that test. The respondent, having defined the appropriate pool, carried out meaningful consultation with the claimant. He was warned and adequately informed throughout, given opportunity to ask questions, and invited to proffer any suggestions to avoid redundancy. His suggestion that more time be allowed was considered, but ultimately was not viable. The respondent too considered and kept under review alternatives, but to no avail, in particular, given the lack of vacancies and the claimant's inability to relocate. In summary, the process was fair. In light of these submissions and the evidence that has been placed before the tribunal, it is therefore respectfully requested that judgment be issued in the respondent's favour and the claimant's claim be dismissed. The respondent reserves the right to address the issue of remedy at a later date, should it be necessary to do so.
The claimant's submissions, please.
Claimant was dismissed by reason of redundancy. The law relevant to such dismissals is contained in the Employment Rights Act 1996, the relevant provisions being sections 139, 1, 98, 2C, and 98.4. Section 98.2C states, in determining whether the dismissal of an employee is fair or unfair, it is for the employer to show the reason for the dismissal, and that reason is that the employee was redundant. Section 1391 states that for the purposes of this Act, an employee who is dismissed shall be taken to be dismissed by reason of redundancy if the dismissal is wholly or mainly attributable to the fact that the requirements of the business for employees to carry out work of a particular kind in the place where the employee was employed by the employer have ceased or diminished or are expected to cease or diminish. In this regard, and on the basis of the financial information presented by the respondent during the consultation process, it's now accepted by the claimant that there was a genuine redundancy situation at the time he was dismissed. Notwithstanding this, the general test of fairness in section 98.4 must be applied, which states that the determination of the question whether the dismissal is fair or unfair depends on whether, in the circumstances, the employer acted reasonably or unreasonably in treating it as a sufficient reason for dismissing the employee. Therefore, the manner in which the respondent handled the claimant's dismissal is important in considering whether the respondent acted reasonably in all of the circumstances in treating that reason as a sufficient reason for dismissing the claimant. In this regard, particular attention must be paid to the process which led to the claimant's dismissal in order to establish whether it was effected in an appropriate way, i.e., within the range of reasonable responses applicable to an employer of the size of the respondent and with such administrative resources available to it. In the case of Williams versus Compare Maxim, when asking whether the dismissal lay within the range of range of conduct which a reasonable employer could have adopted, the EAT laid down guidelines that a reasonable employer might be expected to follow in making redundancy dismissals. These included warning and consulting with the claimant about the proposed redundancy, adopting a fair basis on which to select for redundancy, and considering suitable alternative employment. Whilst the overriding test of fairness in this instance is whether the respondent's actions at each step of the redundancy process fell within the range of reasonable responses, the EAT determined in Claimant versus Ryan that where an employer simply dismisses an employee without first considering the question of a pool, that dismissal is likely to be unfair. Further, in Capita Hartsed versus Bayard, the EAT stated that the tribunal was entitled, if not obliged, to scrutinise carefully the reasoning of the employer to determine if he had genuinely applied his mind to the issue of who should be in the pool for consideration for redundancy. During her evidence, when asked what consideration she had granted to this issue, Ms. Paulson gave a none too convincing answer that she, and I quote, sat down and thought whether I should do it like I'd done the telesales redundancy. She claims to have had, and I quote again, a long, hard think about that and had a chat with Meg in HR. However, when asked to identify any document in the bundle that evidenced any of this, Ms. Paulson acknowledged that she couldn't because there wasn't one. It's submitted on behalf of the claimant that any HR professional worth their salt would know to document this aspect of a redundancy process, and that as no such evidence was adduced by the respondent, it's reasonable to infer that Ms. Paulson did not, in fact, grant any considerations placing the claimant in a pool. Whilst this is something that Mr. Chadwick, the MD, could have addressed on appeal, we know from the documents pertaining to that part of the process and from his own witness statement that all he did was take Ms. Paulson's word for it that she had given due consideration to pooling the RSAs. It's also the case that Mr. Chadwick didn't see fit to interfere with Ms. Paulson's decision in this regard and rerun the selection process utilising a pool featuring all the RSAs. Accordingly, it's submitted that the respondent did not adopt a fair basis on which to select the claimant for redundancy, on the basis that it did not consider what the appropriate pool was. The respondent said it was clear that there should be a pool of one, its reasoning being that the biggest downturn of business and bleakest forecast was in the London region, and that was the claimant's area. It's submitted, however, that the respondent, specifically Ms. Paulson as dismissing officer and Mr. Chadwick as appeal officer, did not genuinely address their minds as to whether to include anyone else in the redundancy pool, despite the fact that it had 3 other employees undertaking RSA roles. It's therefore submitted on behalf of the claimant that the respondent had a closed mind in this regard and had simply decided that it was the claimant who was to be dismissed. When determining the fairness of the claimant's dismissal, regard obviously needs to be had for the size and administrative resources of the respondent. And whilst it's accepted that Buffet King is a relatively small employer, having approximately 50 employees at the time of the claimant's dismissal, it's also worthy of note that the company has an in-house human resources officer and also utilises the services of an external HR support provider. In that regard, we refer to point 12 of Neil Chadwick's witness statement. Despite this ready access to professional HR advice and guidance on redundancy processes, it's submitted on behalf of the claimant that the decision to make the claimant redundant was still made without due consideration of including anyone else in the selection pool, despite the fact that there were 3 other RSAs working in the South, Scotland, and North England and Wales. The overriding test is whether the employer's actions at each step of the redundancy process fell within the range of reasonable responses. It's submitted on behalf of the claimant that the respondent did not undertake a fair selection process, that it had a closed mind that the claimant was being made redundant, and that these actions were outside the range of reasonable responses. In other words, the respondent did not act as a reasonable employer would have done, and so the decision to dismiss was unfair. Like the respondent, we also reserve our right to make submissions on remedy. in relation to Polky. Thank you, Mark.
Thank you, Mr. Nagle. Just one point for the avoidance of any doubt, Mr. Nagle. Is it now accepted that the reason for the claimant's dismissal was redundancy?
Yes, it is, Mark.
Thank you. Okay, thank you for those submissions, and I will now adjourn to consider my decision.
So everybody, we've reached the point where Judge Knowles is going to go away and consider her decision, having listened to the closing submissions from both parties.
Okay, the claimant's claim was that he had been unfairly dismissed by the respondent when he was made redundant on the 16th of April 2021. The claimant gave evidence on his own behalf, and Miss Abby Paulson, Head of Sales, and Mr. N. Chadwick, Commercial Director, gave evidence on behalf of the respondent. The claimant accepted during the course of the hearing that the reason for dismissal was redundancy, a potentially fair reason under section 98(2)(c) of the Employment Rights Act 1996. The only issue for me to determine, therefore, was whether the respondent acted reasonably in all the circumstances in treating that as a sufficient reason to dismiss the claimant. The test of a fair dismissal is set out in section 98 Employment Rights Act 1996. In Williams and others against Compare Maxim Limited, the EAT laid down guidelines that a reasonable employer might be expected to follow in making a redundancy dismissal when asking whether the dismissal lay within the range of conduct which a reasonable employer could have adopted. The factors suggested by the EAT for the tribunal to consider were whether the respondent firstly adequately warned and consulted with the claimant, secondly adopted a reasonable selection process, including its approach to a selection pool, and thirdly took reasonable steps to find the claimant suitable alternative employment. However, the overriding test is whether the employer's actions at each step of the redundancy process fell within the range of reasonable responses. With regard to the employer's approach to the selection pool, the Employment Appeal Tribunal stated in Tamek and Ryan that where an employer simply dismisses an employee by reason of redundancy without first considering the question of a pool, the dismissal is likely to be unfair. Furthermore, in Capita Hartshead against Bayard, the judge found that the tribunal was entitled, if not obliged, to scrutinise carefully the reasoning of the employer to determine if he had genuinely applied his mind to the issue of who should be in the pool for consideration for redundancy. Having considered all the evidence, I have drawn the following conclusions. The claimant did not receive a great deal of prior warning of his redundancy, his dismissal having been effected 2 weeks after the announcement of potential redundancies was made. However, the pandemic placed the respondent in unprecedented territory, and in that context, I consider that the process which the respondent followed in terms of consultation with the claimant was a reasonable one, the claimant having been given ample opportunity to put forward any thoughts or suggestions he had. Unfortunately, he had no suggestions to avoid the redundancy which could be regarded as a viable alternative for the respondent, other than that the respondent could wait to see if the trading situation improved. In view of the situation at the time, it was entirely reasonable for the respondent to reject this proposal. And to that end, I feel that the respondent did adequately warn and consult with the claimant about the potential termination of his employment. Turning to whether the respondent adopted a reasonable selection process, including its approach to a selection pool, this was a more finely balanced issue. The respondent said that it was clear that there should be a selection pool of one. It said that the downturn manifested itself significantly more in the Greater London region, and the prospects of recovery were so weak as to lead the respondent to decide to move its focus away from that area entirely. Notwithstanding that this was the case, the documentary evidence made available to me, namely the note of the initial announcement meeting, the notes of the 2 consultation meetings with the claimant, the dismissal letter and the appeal outcome letter, did not indicate to me that Miss Paulson had genuinely addressed her mind as to whether anybody else should be included in the selection pool, despite the fact that the respondent had 3 other employees in the role of RSA, one of whom covered the south of England. In addition, whilst Mr. Chadwick had promised to review this decision further, his investigation did leave somewhat to be desired, being only a seemingly very quick conversation with Miss Paulson immediately following the appeal hearing, immediately following which he delivered his outcome to the claimant. However, this point was the subject of cross-examination by the claimant's representative, and a further question from myself, to which Miss Paulson gave further evidence regarding the thought process she had undertaken at the time and the factors that she had taken into account in considering whether it was in the best interest of the company to extend the pool. Those reasons were that the primary sales in the other regions related to events, whereas in the claimant's region, they were primarily related to meetings and office catering, and the fact that there would have been potentially negative implications for existing client relationships if the claimant had been moved to another region. Whilst another employer may have taken a quite different view, it is not my role to disagree with the decision the respondent made unless it plainly fell outside the band of reasonableness, which I am satisfied it did not. It is unfortunate that Miss Paulson did not articulate her reasons at her consultation meetings with the claimant when he questioned why he was the only one to have been put at risk, but I am not of the view that this was sufficient to render the consultation as not meaningful. I am satisfied from the respondent's evidence that there was no suitable alternative employment which could have been offered to the claimant, Ms. Paulson having given evidence that the respondent made a total of 15 of its 54 employees redundant at this time, and that there were simply no vacant roles. My decision is therefore that I find that the respondent's decision to dismiss the claimant was fair.
Whether you've had experience in these employment tribunals or not, I'm sure there'll be many questions or thoughts as you reflect upon today. But if I can start with maybe one question to addressing it to Cheryl. The judge's decision indicated it was a close call, however you might think otherwise. So would you have felt confident in taking this case to a tribunal for a client?
Notwithstanding that I am generally quite confident in my abilities, as everyone will tell you in the office. Look, it was by design. It wasn't going to be interesting for you guys if it was a slam dunk, was it? So it wasn't ever designed to be the strongest of cases going into it. The question of pooling was one that was always going to be key, because there were clearly two ways that could be done. And I don't think you could have argued that pooling would have been unfair, but at the same time, it's one of those things. It was key in this case to evidence that the respondent had applied their mind to it, and that's the test. I think in this case particular, the respondent could definitely have done a better job up front in terms of documentation and a paper trail. The less you have in documents, the less you document your discussions, your thoughts, etc., the more it forces you to rely on the witness. So in this case, what if Abby Paulson hadn't held up so well? What if she'd given more ground that could have swayed this case? If she hadn't been able to offer sort of a clear and detailed answer to the judge, then this case could have gone a different way. I mean, suppose we have to go into every hearing knowing that there's an element of litigation risk. But no, in this one, I definitely think that there was more that could have been done to go into that hearing with a little more confidence.
Thank you very much. Catherine, maybe it's appropriate at this stage just to ask you if you wanted to refer to any of the questions that have cropped up in the chat along the way during the course of the morning so far.
Yep, so I've had a couple of direct ones and a couple that I think have been shared with everyone. So I'm going to start from the top. So Hayley posed a question with regards to, I think it's very difficult to identify a clear difference in the job roles, sales for catering and sales for events, very similar skill sets, and presumably in a world of post-COVID remote working, geographic location is not as important as it was pre-pandemic. Whilst the outcome may have still been the same, I think all the sales reps should have been pulled to allow for a fair process. So it was more of kind of a statement than a question, but I don't know if I want to answer.
I mean, I think the thing is that we talked a bit about this in our room, didn't we? And yeah, I mean, certainly one of the things that the respondent even noted in this case is about the move to hybrid working, home working, increased use of Teams and Zooms. And I suppose if we had more than a couple of hours to put this in and flesh out statements, flesh out cross-examinations, that's certainly something we'd have gone into more detail on, because you've got to very much look at the role. And again, it would have been a case of applying the mind. Why did Abby not consider that he could do remotely? And I suppose that in itself boils down to the role, the sales role. It is one of those things that you build relationships and trust better when you can do them in person. And if you need to put your trust in someone, you do need to trust someone that's selling to you, generally speaking, unless they come with a strong recommendation. You want to build that relationship, and for a salesperson going forward to get that repeat business again, it's all about that relationship, isn't it? So certainly in this case, I think that would have had to have factored in. We also talked about the fact that job descriptions, they're seldom the full picture, because they're often written in a way to give a business flexibility, agility to change that. I mean, we've all had to adapt these last few years. Or the last couple of years with COVID, we've seen how those businesses that can adapt and pivot are those businesses that do best. So anything that, promotes agility. So, with job descriptions specific, but not too specific, I suppose. But yeah, that was definitely something that would have, had we had more than a couple of hours in the morning, would have no doubt been pressed and being expanded on, because it's a really good point Hayley's raised there.
What were the other ones, Catherine?
For more? Yeah, so another one was, what's the most important thing a witness should do to prepare for a tribunal hearing?
Well, I mean, preparation number one is to go back over your notes, your paper trail. And that's another thing that makes the paper trail so important, because it's not just about showing that you had those thoughts at the time, but it's an aid memoir for yourself. These tribunals, especially at the moment, you can go into them 12 or 18 months after the fact, and having that paper trail to remind you is great. Having a debrief with your professional representative, it's something that I always like to do with clients, and go over things like, if there are weaknesses where they are likely to be, prepare them for the cross-examination that's likely to come. Tips on how to deal with cross-examination, because it's a very different type of questioning, and it's designed to be so. I personally, with my training, one of the things we were trained to do is how to effectively cross-examine a witness. It's a very specific way of doing it, and witnesses get backed into corners. So I think preparation of having that debrief as well, where you can explain to them what type of questions they can expect, what type of areas the other representatives likely to hone in on, but also how to deal with those types of questions.
Yeah.
We had that discussion in the breakout room that I was in as well, Cheryl, and pretty much echoed what you said there, that preparation is key. Know your bundle, know your statement, difficult to always know the bundle in its entirety when they run to 300, 400 pages on occasion, but at least know the documents that your statement refers to and that your representative tells you you're likely to be referred to under cross-examination, and pay close attention to any witness briefing which your representative provides you with. Take it seriously, don't lark about, because if you crumble on the stand, it's not a nice experience, because the other side's representative is there to make you look like a liar, a cheat, a fraud, and crap at your job. That is their main purpose, and they'll do everything they can and deploy every trick in the book to make sure that that witnesses are exposed in that light.
I think that's key as well, is that people walk into tribunals with a misconception that if what they're saying is the truth, it will be believed. But actually, part of my job when I'm cross-examining is to almost make you doubt your own truth. So just going in and taking it as, well, I don't need to prepare. Look, at what I did was right, and I'm an honest person. An honest person doesn't always come across well on the stand if they're unprepared, and the nerves and the lack of preparation will be ultimately picked up on by any representative worth their salt and exploited.
Can I just raise one other point as well, which is something that Dawn mentioned in our breakout session, and it related to the discussion which Abby Paulson said she had with the external HR support provider. And what Dawn asked was, should some evidence of that discussion have featured in the bundle? And the answer is absolutely, it should have done. And the fact that it didn't gave me an opening to claim that it didn't. And so wherever advice on an aspect of a redundancy process, in this instance, that's as important as consideration of the pool, takes place with an external HR support provider, then you, as the external HR support provider's client, are well within your rights to request a copy of the advice report. If it was a telephone conversation, alternatively, your representative should be certainly asking you for a copy of any email that went between the two of you in relation to the question of pooling. So it's just something else to mention.
Can I just come in with a quick point there, just going back to witnesses being familiar with witness statements and bundles? It's just worth always making clear that witnesses are aware that they can't take annotated documents onto the witness stand. When obviously we're looking more at in-person hearings, they've got to, it's a clean copy of the bundle and the witness statement that will be in front of them. So sometimes witnesses come in with bundles they've written on and put post-it notes on, etc., but those aren't allowed on the witness stand. There's no annotation on the documents that the witness will be looking at when they're cross-examined. That's why it's so important that they are familiar with that bundle beforehand, because they won't be allowed any notes.
An alternative to redundancy, could the company not have considered continuing to place just Mr. Cookson on furlough for a longer period, but have the other reps return?
Yeah, well, that's something which was touched on earlier, that continued use of furlough is always an option for an employer as a means by which to avoid having to make a redundancy dismissal. And but it's not to say that that has to happen, but it would be a good idea for it to be considered and for that consideration to be documented, so that that document can then feature in any bundle that pertains to a claim which arises out of a dismissal relating to that situation.
It might be worth saying, Chris, that there have been some conflicting decisions on that at tribunal level already coming through, haven't there, in terms of first instance decisions where tribunals have found both that it was unreasonable not to consider further furlough, and others that have found that it wasn't unreasonable, it was purely the employer's decision. So there's a bit of
so we're on the side of caution.
Yeah.
I mean, as we near the end to it, it's going to become less and less of an issue, because obviously the closer we get to the end of the scheme and it is. But then there's the fact that if you keep one person on, then you've got to still be doing all the administration for that. And if you're reducing the headcount quite significantly, this is a sort of a medium-sized business that reduced by 15 people. Yeah, I mean, it should be given consideration, but the onus on the respondent to do that as we get closer to the end will go. So hopefully moving forward, it's not going to be such an issue. So.
Okay, another one we have is if location and regional economic results were not a factor and all reps worked in the same location, would a selection criteria pool be more important? And also, would all reps then be needed to go through a consultation process to identify who would have been selected for redundancy?
Well, you'd certainly place them all at risk and in the pool, and then there'd be an element of consultation with all of them to begin with, where you would discuss the way in which they would be scored, ideally. Once those scores have been applied, then perhaps you would be notifying certain people that they're no longer at risk of redundancy. And that would, of course, boil down to the actual scores themselves. If you've got a few people that are close, sometimes it's easier to sort of put consultation on hold with those that appear to be safe until you've got the person who remains at risk and who is scored lowest to go over any objections they might have to scoring in case that needs to be changed. So it would likely have made a difference in this case because, of course, the geographical area and the clients within that geographical area were a factor. But it all boils down to each individual case. It's whether you've applied your mind and whether your conclusion is a reasonable one. It doesn't have to be the only reasonable course of action. It has to be one of them. So it would really depend on how different the work of a particular kind was. If the way they sold to certain clients was different, if the processes they follow are different. But then you would take into consideration the transferable skills and make a decision at the end of all of that. And I think that's the point of applying the mind, is you should take all of those things into consideration, and that when you've done that and come up with a decision that is on the face of it reasonable, you should succeed in terms of the pool argument.
So final question, and thanks everyone, some great questions have been posted in the chat, so I really appreciate it. So from a kind of HR role perspective, what can I do to give my company the best chance of defending a claim?
Ring EML. I know it's cheesy, but I suppose that's the thing, is that actually having a sounding board, having someone else to talk it through. When you are looking at your own decisions, sometimes it's difficult to look at and say, is this a reasonable one? So having that person like a sounding board, making sure that you are having a meaningful consultation. So get that information out there to the people that are at risk, because without that information, they can't really participate themselves in a meaningful way. Get your paper trail, get your documents, they're so key. If you are scoring, if scoring is necessary, if you are dealing with pools, then as much as you can, include things in that scoring matrix that are easily quantifiable, where you can back it up with statistics and data. It won't be wholly down to that, but if you are going to have things based on sort of quality of work where it's not scored off appraisals and things, if you can have if you're having two people score, have a framework to apply to it. Consider alternatives to redundancy. That's ultimately the purpose of consultation, is to reduce or minimize. So consider any way that you can do that. Any other way you can make those cost savings, retraining, anything like that. We mentioned retraining in our group. You should be considering that. Consider bumping which is moving someone into a different role and bumping out the person in that. So in this case, had he been prepared to move, then perhaps there would have been the option to bump someone from telesales because he would have had greater sales experience than them. There's a lot to do, but I suppose you need confidence that you're following that right procedure. You need confidence that you've thought of everything, which is why it's sometimes so important to have that person you can go and talk to that might see things a slightly different way from you, might play devil's advocate, and you're going to end up with a safer decision because of it.
I think they got away with it a bit for faking, specifically in relation to the consideration of the pool and the lack of documentary evidence there. And certainly Cheryl and I had conversations in advance of the event to the effect that Cheryl was concerned that I was making too much ground when it came to how sketchy Abby Poulsen was on the stand about what consideration she did grant to that aspect of it. So we actually put a bit more meat on the bone in relation to her particular answer on that point, specifically in relation to the conversation which took place between Abby and the HR support provider. But on that occasion, let's say it was a real life scenario, and that what Abby said was true about the advice that was provided by the support provider. The support provider should have gone a step further and should have made a point of emphasising how important that aspect of the redundancy process is to eventual fairness of any dismissal, and kind of ensured that the client was making notes about the process that she'd run through in considering whether to pool or not. But it just seemed like a snatched telephone conversation whilst Abby was in the car that wasn't followed up on by the HR support person. What the HR support person should have done is perhaps followed up that conversation by confirming the content of it in email form to Abby, so that that document was then created and could be called upon by Cheryl as the representative when she was putting together the bundle for the case.
The point is the robustness of the appeal process, because obviously here it was a bit half-hearted, and that's not uncommon in whether it be in redundancy cases or other types of dismissal cases, that sometimes the appeal isn't given the level of rigour that perhaps the original decision might be, and then if there are any problems, the appeal isn't able to remedy them. So I think it's important for people to realise that the appeal process is important and will be considered quite carefully in the tribunal in terms of how thorough it was and whether the decision in this case was properly reviewed by Mr. Chadwick, or whether it was just a paper exercise.